SJC-11127, Commonwealth v. Janelle Garcia.
Mr. Baylor.
Good morning. Jeffrey Baylor for Mr. Garcia. Here we contend that the trial court abused its discretion in failing to allow the defendant to bring in a baby for identification by a witness and to show her to the jury, and that this error was exacerbated when, on rehabilitation, the witness was allowed to give the circumstances of this baby being in the courthouse.
Could I ask you a factual question? The Commonwealth asserts in its brief that the judge obviously declined to allow the baby to be exhibited in the courtroom, but offered other options to the defendant, including, I think, having the mother of the baby testify about the age and who she was, I take it, and the defendant did not take any of those options. Is that correct?
True, yes.
Weren't those alternatives ones that would make the same point, maybe not as graphically or as pictorially, but would make the point?
We contend that it wouldn't have made the same point, because if the baby, the whole issue was this her baby or not? Maybe I should back up and I'm aware of your question, and that's an important point. On cross-examination, unexpectedly, she testified that 3 years before, she had had a baby with Mr. Garcia, and that Mr. Garcia's mother had adopted this, it was a daughter, and that at some point, this witness, Ms. Encarnacion, was told that this baby was passed away, was dead. But then in her cross-examination, she testified that the baby was now brought to court by Mr. Garcia's mother, and and she believed it was to make her nervous and upset. So the issue is whether or not she properly perceived this child as her baby.
Right.
So the child would have been 3 years old at this time if it was her baby. But during a break, after some more questioning of her about this matter, during a break, defense counsel determined and informed the court that this baby was not a 3-year-old baby, but was 15 months old, and it was the baby of one of the cousins of Mr. Garcia. Apparently, according to trial counsel, this cousin and Mr. Garcia's mother were both at the courthouse. They were taking turns holding the baby in the hallway while the other one went in.
Right.
So it comes down to whether or not Ms. Encarnacion was properly perceiving this baby. I mean, the jury, after her testimony, is left with the impression that Mrs. Garcia and therefore Mr. Garcia are looking to intimidate her, to affect the trial.
Right.
So if the baby is brought in, then the jury can see, as defense counsel said, that it clearly was not a 3-year-old.
But I mean, don't you think that jurors would be able to, if somebody comes in and testifies, this is my child, I'm the niece, or I think, of the grandmother.
Right.
This has nothing to do with Jessica Encarnacion. And by the way, the child is actually 15 months, not 3 years and 1 month.
Right, but it has to go to if her perception is right or wrong. So by bringing the baby in, the jury can see that this wasn't a 3-year-old, that this was a 15-month-old, that her perception, therefore her credibility.
So the idea is that it affects her, that she would be, what, an unreliable witness because she was upset about seeing a baby?
Yes, that's one part of it. But the other part is that it would be clear that Mr. Garcia, through his mother, was not trying to affect the trial.
But that's something that somebody else could
Right.
could certainly make clear,
Well-
right? That it's, bring in the mother of the baby.
Right, but
That's my baby.
if it's a 15-month-old, it could look like a 3-year-old. So if someone comes in, the mother of baby, and says, my baby is 15 months old,
So if it looks like a 3-year-old, that
Right.
doesn't help your client at all.
exactly. So we wanted to bring in the baby to show that it didn't look like a 3-year-old, that it looked like a 15-month-old.
Wasn't there's that point, but equally, if not more important, I would think to you, was this intimidation question, which
Yes.
the other person could testify to much better than just showing the baby in the courtroom.
Well, we contend that the baby would make it clear that there was no intimidation, because people in the jury would see, this isn't the 3-year-old, therefore, this baby was brought to the
That the
court.
that the grandmother's bringing, I don't know that those two are exactly the same thing.
Well, I think that that's what trial counsel was trying to bring up, I think he even said at one of the sidebars that any parent would know that this wasn't the 3-year-old. So according to defense counsel, it would have been clear to the jury, just if they had just brought the baby in, this all would have been done, because the jury would have seen that there was no intimidation, because it wasn't something that a person would think was her baby.
But you acknowledge that this is purely a discretionary decision on the part of the judge, right?
We contend that it was an abuse of discretion, because
But the judge would have permitted your trial counsel to call the mother of the child, presumably could even present a picture of the child. I mean, there were other ways of getting at this, and bringing a child into the middle of a murder case as an
Yeah.
exhibit is pretty extreme.
I don't think that the picture idea came up, but
Well-
there was talk about bringing in the mother.
Right.
But, I mean, the point was that if the child was, this whole thing went on for like 3 days. The mother became really upset, they had to stop the trial, and
Let me try to understand this. The mother, first of all, your client admitted that he went to the home of the murder victim
Right.
with 3 other people armed to rob him.
no, he didn't admit that they were there to rob him.
He didn't.
That's something that the Commonwealth wrote in its brief, and that I addressed in the reply
What did he say
brief.
they were due-
He said
to
that they were owed a debt of drugs.
They were what? Ordered
They
it-
were owed a debt.
So they went to collect a debt.
Went to collect the debt,
Armed.
not to rob this person.
Armed, laid in wait in the victim's apartment,
Right.
shot him when he came into the apartment, beat him up,
Well,
duct taped his stepdaughter, threatened to torture her. I mean, this is pretty bad stuff. How is this
Well-
prejudicial to you that the judge wouldn't let a child come in to be identified as an exhibit?
well, because based on Mr. Garcia's version, which is in his statement, they were there to collect the debt. They didn't break into this apartment. They had a key. They went in, they made food, and they waited for this man to return.
In the dark.
In the dark, in his
I
apartment.
think it said that there was lighting coming from the outside.
Yeah, but I mean, they were waiting to surprise him. They
Well-
weren't just hanging out and saying, "Hi, how are you? Hand over the money."
I mean, that's the testimony of the Commonwealth's witnesses. But Mr. Garcia's version, if believed, is that they were there waiting, making supper. I mean, they made fish. It wasn't like they were trying to be there in secret, according to Mr. Garcia. They went to collect the debt. The decedent walked in. His stepdaughter screamed. The decedent went towards one of the individuals, and the gun went off. And Mr. Garcia said it was an accident. It wasn't even,
And then they were there for how long?
well, that's another point in dispute. The evidence showed that it could have been as little as 15 minutes, or it could have been as long as 90 minutes.
What was the condition of the victim when the EMTs arrived at the apartment?
That's right. That they said that,
Was he duct taped and beaten about the head and shot in the face?
I don't think that there was evidence, I don't recall evidence of a beating. I recall the duct tape, and then there was a shot, but the medical examiner testified that it was a superficial wound, that it didn't even penetrate the
But he died as a result of
He died of it.
whatever happened to
Yes.
him
Blood
in
loss
whatever
and-
period of time your client and 3 others were trying to collect a debt from him.
Well, one of the things that was argued at the trial was that the death was the result of the stepdaughter, Miss Cedeno, delaying in calling for help.
Let's assume she had never called. Let's assume she'd never called for help at all. You're saying that what? That her failure to call was a cause of his death?
Yes.
As opposed to the gunshot and the beatings?
Well, it was a superficial wound.
Okay.
And so let's just
But he
say,
died from it,
Right, but
bled
what-
to death.
what happens if he just got a scratch and he just never got treated?
So your claim is that there should have been an instruction, that there was an unintervening cause, right?
Yes, yes, at least give the jury the chance to consider it. I'm not saying that, I'm not saying they would believe it, I'm just saying that they were entitled to.
Doesn't the intervening cause need to be the sole cause?
Of the death.
It does, but we're saying that he would have lived if there wasn't, if
If
her.
she called 3 to 4 minutes earlier? That's
If
what
she,
you're saying?
well, I mean, the evidence can go any way. The evidence best case to Mr. Garcia is that they were there a very short time. The evidence showed that she made 6 calls before calling 911, that she changed her clothes, that she was part of the same drug organization, that her mother was a partner of the decedent, and that it was to her benefit for the decedent to die. Now, all we're saying is that, based on this evidence, that the jury should have at least been able to consider whether it was an intervening cause.
Well, can I
And
just
also-
ask you on that, and what's the longest period of time you say the evidence supports that she didn't call? What's the longest period of
It's
time?
more than an hour, I would say.
So you're saying that the failure to call for more than an hour. Is there any medical evidence that if there had been a call made more quickly, that he would have lived? I thought there was a coronary event
There was, but it was from...
Caused by blood loss.
caused by blood loss. Is
Yes.
there anything in the medical
Well,
evidence about the timing
medical-
as to that?
The medical examiner said it was a superficial wound, which to me means that, the decedent was
Yes,
not
but a
going
head wound can bleed tremendously.
Well, I guess it's true, but I guess it depends on what, superficial is. To me, superficial means that you're not going to die of it.
I'm just trying to understand, if the niece or the stepdaughter had never called at all, would you say failing to call was an intervening cause in
Well,
the death of this person who
Another
was
thing-
shot and beaten?
Another thing to think about, that I talk about in the reply brief, is whether this was foreseeable or not. When even the decedent's stepdaughter testified that when these men left, her hands weren't even bound.
Her feet were bound.
Her feet were bound, but it allowed them to leave, and then her to just easily go and assist the decedent.
Well, okay, well, the testimony about that is what? That she was told, if you call the police, we will come back and kill you.
Well, that's her version, and we're saying
Or another version?
the version is that they
It's his statement? That's the other version?
statement, yes.
Okay.
that
What was
they-
his statement
that
with
they went
respect-
that they just went to collect the debt, and that they left after a short time. There was even testimony that
They left after the short time, but here is someone who's bound hand and foot, shot, and beaten. How is that collecting a debt?
Well,
I mean, yeah, yes, okay, he was there to collect the debt and killed the debtor. I mean, so?
it just sort of evolved into this. That was not the intent.
Did she have a duty to seek help, a legal duty?
I didn't investigate that, but I imagine not. But it's just
Well, so
it goes to
couldn't the same argument be made about the defendant, that he had an obligation to call for medical assistance?
Well, I think that the defendant left the stepdaughter his hands free so that she could go and help. According to his testimony, they left after a short time, and she was only bound by the feet, and that it wasn't foreseeable that she wasn't going to go and help him. There's evidence to the contrary, but we are concerned that the jury was properly instructed as to, the possibilities that they could find.
Can I switch gears?
Sure.
On the second-degree felony murder
Yes.
charge. Did the defendant asked for a second-degree felony murder charge based on joint venture to
To
get
distribute,
drugs, to distribute drugs?
cocaine, yes.
So that
saying-
was asked for, it wasn't?
Yes, it was asked for, and it was that, the argument was that this was a big drug organization. They weren't there to invade the home or anything like that. There was no evidence of a break-in, and that they were just going to collect the debt as part of this, to get drugs to distribute.
What, assuming for the minute that instruction should have been given, doesn't the fact that the jury convicted your client of first-degree murder on an extreme atrocity or cruelty theory make that fairly harmless?
It would, except we also argue that the extreme atrocity or cruelty argument was improper because the judge specifically said that accident wasn't involved. And we contend, based on Mr. Garcia's statement, where he clearly said there was an accident, that accident shouldn't have been taken away from the jury as a potential issue in the extreme atrocity or cruelty.
But what's the evidence of accident?
That when the decedent entered the house, there was a scream and he lunged at this person and the gun went off during a struggle.
So they beat him afterwards? They beat him after the shooting?
I don't think, I'm not recalling the evidence of a beating or if there was or anything severe. Clearly, if they wanted to kill him, he was bound and they had a gun and they could have killed him.
Well, they didn't do it right. I mean, that's not what he was indicted for. He was indicted for actually killing him, not for having it done, not for having committed it the way you suggested.
Well, I'm just saying that that's something to think of towards an accident, that there was a struggle, the gun went off, there was a superficial wound. They tied this guy up because they wanted to collect the debt and he wouldn't give them the drugs.
It was Cedeno that testified to hearing them beating him up,
Okay.
remember?
Okay.
Yeah.
I'm sorry, I didn't recall that. And just in my remaining time, I just wanted to mention one thing about the first issue that we talked about. Besides bringing in the baby, we contend that this error was exacerbated because the Commonwealth was allowed, as part of rehabilitation, to have her recount the details of seeing the baby in the hall. She said that the baby was being held next to the DA's office, exactly where she had to walk, and she said that she was intimidated by this. So we contend that beyond not allowing the baby to be brought in, this error was made much worse by allowing this witness to basically testify that she was being intimidated by Mr. Garcia.
But that sort of goes again to the point of, wouldn't it have made sense for the defendant to have called the mother of this baby? I mean, one could deal with all of those things, and maybe the explanation by Ms. Encarnacion would have been unnecessary.
Yeah, again, it wouldn't be the end all, because no matter how old the baby was, the baby could properly be perceived as the 3-year-old. And plus, I mean, it was a decision for counsel to make once this error was made, how to try and cure it. If the family, the cousin or the mother is brought in, then it could be making the problem even worse, because then the jury is thinking, oh, their mother was involved, their cousin was involved, and there's examination about how the baby was held, where the baby was held, and all of this extra stuff. Whereas if the baby was just brought in, they see it, it's over and done with. I mean, there was a demonstration as to height where other individuals were brought in this case, so they could compare the height of the shooter with these other individuals. It would have been exactly the same thing. The baby could have come in for 30 seconds and said, the witness could have identified it, yes, that's the baby. Oh, and if the baby's never brought in, the baby is never identified as exactly that's the baby that everyone is talking about.
Thank you.
My time's up. Thank you.
May it please the court, Kenneth Steinfeld for the Commonwealth. I would first like to address several statements made by the defendant, both in his brief and this morning, and that is to the effect that the defendant said in his statement that he merely went there to collect a debt or to be there when Gringo helped to collect a debt. The fact is, he said a lot of things in that statement. He didn't just say that, and I want to point the court to pages 53, 91, and 105 of the record appendix, which is the transcript of that interview that the police had with the defendant. On page 53, he tells the defendant, we were going to, like, take something from Calvo, which implies something more than just collecting a debt. There's the use of the word take.
Weren't they, maybe I'm wrong about this, but wasn't there a suggestion that the collecting the debt was going to be in the form of getting drugs?
Yes, that was a suggestion that the defendant made during his interview, but he said many other statements during
But
that
I mean, that's
interview that
taking.
contradicted that.
Isn't that taking?
Well, I think of taking as something different from collecting a debt. But the other statements I'm going to refer to are clearer than that. If you look at page 105 of the appendix, the Spanish-speaking detective says to the defendant, you said everything, that you went there to rob the man, that he didn't die. You said all that. So he says, you went there to rob the man. And the defendant's response is, of course. So he is adopting the statement of the detective. The third thing that shows from the statement that this was not mere drug collection, but a drug rip, was he said that Gringo told him beforehand that after tonight, they would be able to live as retirees. And that's on page 91. And if the defendant is merely accompanying Gringo to the victim's apartment to collect a debt, that doesn't make any sense that both he and Gringo would thereafter be able to live as retirees. It shows, and he also admits that they knew that the victim received a large amount of drugs from Texas that day, and the defendant, and this is remarkable, admits in his statement to police that that afternoon he and Gringo went over to the building, went inside the building, came out the building, so they cased the joint that very afternoon. This is completely inconsistent with the idea that they went there solely to collect the debt, although he does at one point in his statement also say that, but the jury were certainly permitted to credit those statements in his statement to police that he was there to rob them, that he'd cased the joint, and that he believed that he would get rich as a result of it. So the notion that the defendant's sole statement of what happened was to collect the debt is just not true.
Was the defendant's statement audio or video recorded?
Yes, the statement was audio recorded, and the recording was played in court, and the jury were provided with a translation that they got to keep. That was also admitted into evidence.
Was the audio recording in English or Spanish?
Pardon me?
Was the audio recording in English or Spanish?
It's in both. There were two detectives there with a state trooper plus the defendant. The state trooper spoke English, and he led the investigation. There was a Lawrence police detective named Burke and a Lawrence police detective named Carlos Cueva, who acted as a translator. And most of the time, Trooper Labarge would speak in English, and Detective Cueva would translate, and then the defendant would answer in Spanish, and then Detective Cueva would tell the trooper. But on several occasions, the defendant responded directly to the English language questions posed by both Trooper Labarge and Detective Burke.
I take it, at least I didn't see from the briefs, that there was any objection to the accuracy of the transcripts,
Well,
the translations.
That's correct. That's another very, very important point. There was objection to the authenticity of it, but no one has ever said that a single word of the translation that was submitted to the jury was a bad translation, that take does not mean take, or rob does not mean rob, or retiree does not mean retiree. There's never been a challenge to that.
Was the portion of the exchange about robbing and about retiring, was the defendant's response in English or Spanish? Do you know?
Spanish, yeah, yes. He spoke Spanish throughout. I'm almost 100% certain that he spoke Spanish throughout the interview.
Okay.
But he did, as I say, respond to several of the questions posed in English.
So let's go to this, the witness, what was her name again? The defendant's girlfriend?
Jessica Encarnacion.
Jessica. Jessica. Now, I take it Jessica and the defendant fled to the Dominican Republic right after this happened,
That
right?
very night.
Okay. And
I'm
she
sorry,
re-
that very morning.
That
'cause
very
it-
morning. And she returned several months later, right?
In February of '06, and the murders occurred in August. I'm sorry, February of '05, and the murder occurred the previous August. And she's pregnant.
And at the time that she returned, she was interviewed by the police, and she also went into the grand jury?
Yes, she did, on March 9th, 2006.
And her statements at that point were exculpatory of the defendant?
Yes, because she was still in a dating relationship with him, and she was carrying his
His
baby.
child. Okay, so after the child was born, I take it that she and the defendant parted ways,
I believe they parted ways prior to the birth of the child.
okay? All right, no, that's fine, that's
right.
fine. But at some point,
ways in
she,
June.
at some point,
Pardon
she,
me, Justice Botsford?
I think they parted ways in June, is what it said.
well, it doesn't matter whether it was before or after, but at some point, she began
Yes,
to
yes,
tell.
they parted ways in June, and the baby was born in August, so.
All right. At some point, she began to tell a different story, which was very inculpatory of the defendant.
Yes.
Is that correct?
Yes,
All right. And so when she testified at the trial, it was inculpatory
yes,
about what he
Highly.
said when he got back to the apartment, his
Certainly.
bloody clothes. There are conversations about what happened, right?
absolutely.
All right. So on cross-examination, she was obviously being impeached with her prior grand jury statement and her other statements, right?
That's correct.
And about what motive she might have for now telling a different story.
Right.
So how does the baby issue come up in that context?
She gives a non-responsive answer. He's asking her, the defense counsel is basically going through the standard litany of questions. Well, you say this now, but at the grand jury, you said this. And she said, to explain why she had done that, she said, I am telling the truth now, and I was not then. And then she just blurts out that the defendant's mother, she saw the defendant's mother. Well, I'm sorry, back up. She says, I have 3 children, one of whom was taken from me by the defendant's mother, and she told me that the baby was dead, and I believe for 3 years that she's dead. And so that's the context of when it comes up. It's not directly responsive to, did you tell the grand jury this, and now you're saying this, but she was trying to explain why her testimony had changed over time. And also, she was very upset on the stand, or she became very upset, and this was to explain why she was upset. But as I said in the brief, nobody expected her to say that.
Okay. All right, so then what happens?
Well, then the defense counsel probes further as to this belief, and it becomes an issue when she breaks down, and they have a recess and a break, and court adjourns early, and there are extensive discussions about her state of mind, her testimonial capacities, her perceptions, and also the issue of the possible prejudice to the defendant if the jury thought that the defendant or his family had somehow acted in concert to bring this about.
Okay. All right. So defense counsel says, the witness has said that she has seen her child outside of the courtroom with the defendant's mother.
Right.
And believes that this was an effort to intimidate her or to upset her, right? This is the context?
Yes.
And so defense counsel says, let's bring the child in. It's not the child. Let's bring the child in so the jury can see.
Yes, he said, I need the child. I need the
Not a
baby.
3-year-old child, it's a 15-month-old child. Let's bring her in here so the jury can see that it's not her child.
Right.
Therefore, this is not something that's been done to intimidate her.
Well, no, it was to, well, that in part, but his main concern was to show that her testimony was not credible, because if she believed that that her deceased 37-month-old baby was in fact a much younger, smaller baby, then then,
Show that she's disconnected from reality.
right, that you can't tell
Not a
what.
reliable witness.
Not a reliable witness.
Right, so that was the principal concern. That's the principal reason that the defense counsel gave why he wanted to bring in the baby, to show that she was delusional. He used the word psychotic at sidebar. He said, Judge, this is psychotic. This witness is untethered to reality, and I need to bring in the baby. He said, it's the only way that I can do it is to show that she's disconnected, because everyone knows that a 37-month-old baby looks very different from a 15-month-old baby. And so he says that that was the only way that he could make that point, but has been pointed out earlier by Justice Botsford and others, he had plenty of other ways to prove that. And the fact that he didn't take any of them doesn't mean that he should now be heard to complain that the judge abused his discretion when he wouldn't bring the baby. And the judge has the discretion to prevent the embarrassment and the harassment of a witness. And here he clearly acted within his considerable discretion because he did not foreclose all inquiry on the matter.
And is it correct that not only that he didn't foreclose, he actually presented these alternatives? Did
Yes.
he, Judge Lowy?
Yes, not all of them. He said, well, this is a way, and he said several times during the trial, well, I can think of plenty of ways, but you're the lawyer. But he did make a suggestion that the mother be brought in, but he expressed a fear. The defense counsel expressed a fear that the jury would think that they had switched babies or something like that, which I think is irrational. And if the mother had come in, as you say, with photographs and said, I gave birth to that child, I am the woman who was wearing the red shirt yesterday, and I am the niece of the defendant's mother, I am the defendant's cousin, I came to support my cousin, my child is 15 months old, he was born on this date, he weighs this many, or she weighs this many pounds, she's this length, she doesn't look 37 months. I don't know whether she could say that, but she could certainly give the dimensions of the child, and that would be virtually as good. I can't see there would be a substantial difference between that testimony and actually parading the baby in court. And I think that it would have been unbelievably traumatic for Jessica to have the baby brought in, shown to her, because she continued to believe, even after she saw the baby, that it was hers. So defense counsel would want to bring it in and show it to her, and then show it to the jury.
Wasn't there some effort made to have her see the baby again after she broke down on the stand?
Yes, after court, on that day, once the jury had been dismissed, they arranged for her to go and to see the baby. And she maintained afterwards that that was the baby, that it looked like her baby, that it looked like a 37-month-old, that it looked like the defendant, its father. So she continued to believe, even after seeing the baby up close, that it was her baby.
Was there ever any effort on the part of the defendant to bring in evidence of that? In other words, this continuing untethered to reality?
Yes, that was part of the evidence. I'm not sure whether that came in on cross or on redirect, but the jury was made aware that even after, that's the hallway encounter, that's the rehabilitation evidence. The jury was told that she went out of the hallway and saw her, and she still persisted in her belief that it was her child.
If we could move for a moment to the question of whether there should have been an instruction with regard to accident, whether the jury should have been
Yes.
instructed that they could find that the shooting was accidental. Why wouldn't that be appropriate here where the defendant's statement was that the gun went off by accident?
Well, his statement that it went off by accident does not make it an accident as a matter of law. That's a colloquial statement. Of course, accident has a legal meaning, and the appeals court in Faloma and Figueroa has gone to some length to explain what that means as a legal matter. And an accident is something that is inadvertent, mistaken, or negligent. It is not something that is wanton or reckless. There was no evidence before the jury. Well, I'll back up. The scenario posited by the defendant is that there were 4 men in a darkened apartment, and there may have been lights coming through the window, but there were no lights on in the apartment, and that the shooter, may he be Gringo or the defendant, is standing near the doorway. the victim and his stepdaughter come in, and she goes to the bathroom. And the victim steps into the dining room, living room area and sees a man, and he lunges at him. And that man just happens to have a loaded firearm out, brandished, pointing at him, and he shoots him as he's lunging at him. And I think a man standing in a darkened apartment, when he's there, even if he's there just to collect a drug debt, which he's not, a person standing in that position with a loaded firearm in a darkened apartment, lying in wait for the owner of that apartment to come home, and knowing that he's going to come home, perhaps with a large amount of drugs, it's no accident. It is, there's no way that a
At
jury...
best, it's wanton and reckless.
At very best, if not intentional, there's no way that a rational jury could have found, based on that scenario, that it was inadvertent, mistaken, or negligent.
So the judge instructed that accident was not an issue in the case?
Yes, he explicitly instructed that you cannot consider accident on the first-degree murder by extreme atrocity or cruelty.
And that was not objected to at the time?
Right. There was no post-charge instruction. As the defendant concedes, I believe, in his brief, he argues substantial likelihood.
Was the murder weapon examined by state police?
No, they could not find it. They went on 2 occasions to look in the wooded area off of 495, where Jessica said the defendant had dumped it on their way to New York, but despite the fact that they had 20 or more people looking for it, they never did.
So that there was no evidence that the gun malfunctioned?
None at all.
It may not, but some of these facts seem somewhat similar to Commonwealth versus Dyer. Is this ringing any bells to you?
Well, Dyer, to me, of course, is a courtroom closure case that I've cited a million times.
No, but it did have an argument about an accident with a gun going off and shooting the victim, but
Well,
it didn't come
I
up.
didn't cite it, and I missed it if it does.
Well, it probably doesn't, so never mind, move on.
Okay.
But can I ask you about the second-degree felony murder
Yes.
question? Because I think you suggest that because, the fact that it was asked for, doesn't that make it different from Stokes?
Yes.
So,
I'm saying that the dictum in Stokes, not the holding in Stokes. I said in my brief that Stokes strongly suggested, I did not say that it is binding law. I said that it strongly suggested that a second-degree felony murder instruction is appropriate, though the Commonwealth doesn't seek it, when the non-life predicate felony is either a charged non-life felony or a lesser included offense of a charged felony. And I think that does, it said in Stokes, actually this court said in Stokes, that perhaps strikes an appropriate balance.
but that was after the fact. In other words, it was a motion for new trial.
Right, but
Been raised at trial.
right, but the court said in Stokes that it was not error for the judge not to give the second-degree felony murder count, at least where there's a request. I candidly admit that there was a request here, but that still does not give the defendant license, as I said in my brief, to scour the record and find any and all freestanding non-life predicate felonies that could, in theory, become the basis of a second-degree felony charge. That's not fair to the Commonwealth, and that doesn't make sense. If the Commonwealth cannot send a charge to the jury that there's no indictment for, then it doesn't make sense for the defendant to be able to say, well, I'm entitled to second-degree felony murder based on an uncharged non-life felony that's not part of the case, and the Commonwealth did not know until trial that there was going to be this drug distribution defense. So as this court noted in Stokes, that the rule that I put forward, that is the Stokes rule, puts everyone on notice what the potential predicate felonies for the felony murder are. And think that to expand it in this case would not be correct or fair. And I think that this court should adopt the suggestion in Stokes that a proper balance is that a defendant is entitled to an instruction on second-degree felony murder only when the suggested non-life felony is the subject of a separate charged indictment or is a lesser included offense of a separate charged indictment.
Thank you, counsel.
Thank you.